Hi, today I am going to share with you about the remedy the plaintiff has when defendant files an application to reject the plaint on the ground of locus standi. Now, locus standi means plaintiff has no right to come to court. That is a simple meaning of locus standi. In a simple analogy, I would say that if somebody must go to hospital, they must have a health disorder. They must have a dent to their health. That is to say, something must happen to their health. That is, they must be unhealthy to come to hospital. In the same way, there should be a monetary loss for somebody to come to civil court. Some sort of damage must occur to the plaintiff by the defendant directly or indirectly. Then only plaintiff can enter the court premises. Without pleading that damage in the plaint, in the court case, plaintiff cannot enter the court compound. Court will throw the case out of the court if there is no damage pleaded. Please try to understand. Not to be proved, damage has to be pleaded. Proof comes later. If you don't prove, eventually the case gets dismissed. But you have to plead that defendant caused damage to the plaintiff. Without that pleading, your case will be thrown out. Now, the general application that is filed by most of the defendants is just to try for rejection of plaint. Now, it is very clear that in a civil procedure code, rejection of plaint can be done only on specific grounds, not on locus standi. If plaintiff doesn't have a case, that is a question for a trial. That is a question based on evidence. That is, plaintiff doesn't have right to come to court is not a question to reject the plaint. He may prove it in the process of trial by leading evidence, but not to reject the plaint. That ground cannot be taken. So, if anybody pleads that plaintiff doesn't have a right to come to court, then in legal terms it is called the locus standi to file a case. Plaintiff doesn't have a locus standi to file a case, then the application that is filed by the defendant, which is called an application to reject the plaint, will be thrown out, because rejection of plaint will be rejected on a specific grounds. Now, what are the grounds that are to be taken or that will be considered by the court when an application is filed to reject the plaint are: one, the plaintiff must not have any cause of action. Now, what is cause of action? That is earlier in a couple of minutes ago, what I told you is that the damage that is caused by the defendant to the plaintiff is cause of action. That is, the cause to take action is cause of action. And the second is, it must be written in law that you cannot file a court case. It is written. In some circumstances, some specific circumstances, law categorically said that applying those circumstances, court case cannot be filed. There are many circumstances. I will give you a simple circumstance. For example, a person gave X amount of money to another person. The lender gave money, X amount of money to the borrower, and by executing a promissory note or without any promissory note also, the lender has to recover interest or the principal, or at least demand within 3 years to the borrower to repay the money. If there is no sort of demand, if there is no payment of interest, or if there is no payment of principal or part interest or part principal from the borrower to the lender, it is written in the law of limitation that the promissory note is expired. So now it is clear that the law of limitation for money recovery is 3 years. Now this is very clearly written in law. Now if plaintiff comes and files a suit even 1 day later, then that suit will be dismissed because it is barred in law. It is very clearly written in law that you cannot file a suit after 3 years. So that is the other ground, the second ground. The third ground is if there is no court fees or insufficient court fees or insufficient valuation, because every property has a valuation, every court case has a valuation based on which you pay the court fee. So improper valuation or improper court fee or insufficient valuation or insufficient court fee. The rest are administrative grounds, like if you don't file a duplicate copy of the plaint, or if you don't file copies for the other side. So these are the 6 grounds that are taken for rejecting the plaint. Remember, if defendant pleads that the plaintiff doesn't have the locus standi, that is to simply say the plaintiff doesn't have the right to come to court, the right to file a suit, that is only subject to evidence but not at that stage for consideration through the application filed to reject the plaint. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.